So thank you so much for joining us today. My name is Elise Rosemarin. I'm a Senior Vice President here at AKAM. Again, we really appreciate you joining us. Today, we're going to be discussing preparing for building emergencies, how to make the best outcome of the worst scenario, which unfortunately happens too frequently. So joining me today, I have a really great esteemed colleague who is coming to us from Becker Attorney Law. He is a partner. His name is Stephen Anderson. Thank you, Stephen, for joining us. And then we also have Christopher Alker, who is the Senior Vice President here at AKAM of Building Operations. He's also an in-house resident architect, as well as Brian Boak, who is a Director of Risk Management here at AKAM. Thank you all, gentlemen. All right, so what are we talking about today? Let's see. When crisis strikes, what should a board member do? Obviously, effective crisis communication is key. What are the legal responsibilities of board members? How to navigate insurance and financial fallout, and then we will be doing a Q&A session. If you have any questions, please feel free to ask during our time here with you. We will try and incorporate it into our presentation today, and if there's any other questions after, we will circle back to you because we have your information. All right, so let's get started. When crises strike, what should a board member do? And what are some real life scenarios faced by boards? So without further ado, I guess we'll have Stephen kick it off, who has seen too many, I bet.
Hi, everyone. Nice to be here with you. Yes, in 40 years of practicing law, sometimes it feels like 400, I don't know, but I've seen a lot. I have my own firm for many, many years, and joined Becker, a larger firm, which gives me more support, among other things, for the kinds of crises that can come up. But enough about me. Let's talk about you as board members. You signed up to be on a board. We know you didn't do it for the money. You did it because it's a place you live, and you certainly want to do the right thing and help help your fellow neighbors, shareholders if it's a co-op, unit owners if it's a condo. Well, you never know what you sign up for. And all of these items, and this is not the ordinary course of business, general stuff of co-ops and condos. I mean, things happen at buildings. Maybe it's happened at yours. I mean, I've been involved in many emergencies and serious problems, and it can go for a long time, a year, 2, 3, 5. It can lead to battle fatigue for board members. It's a lot. I mean, going down the list here, I represented a Park Avenue condo, and they discovered mold in the building, which wound up, it was one of the earlier buildings where mold was found, and guys in moon suits wound up going through the building, and it is serious stuff. The next one was a condo I represented up. It was actually in Westchester, and lo and behold, we heard some contractor was doing work, and there was asbestos flying around on the street. Next, I had one where there was a fire at a condo in Brooklyn, and the buildings department came in and issued a vacate order, and et cetera, et cetera. And the others on this list, I mean, it's unfortunately too common. Shareholders and owners can get in disputes, fights, maybe physical. And then a couple more on the list you see, leading to floods in a building, and another one with elevator outages. So what do you do as a board member? How do you deal with this situation? The next item on the graphic, really key questions to ask immediately. It sort of deals with the how. How do you communicate? How do you deal with the problem? And the answer is you need to contact your key players and let them guide you. And that's sort of obvious. I mean, that's why you hire a managing agent. You may have less dealings with your lawyer. Believe me, your lawyer is going to get involved, your insurance expert, and it's a process. And after dealing with an immediate emergency, for example, if you had to call the police or an emergency contractor or the city of New York to deal with any of the above situations, and your lawyer and managing agent will guide you on that. after the first 24 to 48 hours, where it could well be some type of triage situation, you settle down a little, and what do? Well, um, the first thing you want to do is you want to establish how you're going to communicate going forward. The thing not to do is having, you could be a 5-person board, you could be 7. I actually had one 11-person board, which is pretty big. But the first things you do is you establish who is going to be communicating with your managing agent, who is going to be communicating with your lawyer. A guaranteed way to get everyone angry at everyone is if everyone starts barraging the lawyer with emails, and the lawyer trying to do the right thing, seeking some kind of legal sanehood, answers everyone as quickly as he or she can, and then you get some crazy legal bill and you're not a happy camper. So, that's not the answer, to have board members all contacting counsel or the managing agent or anyone else. I mean, you need to establish some type of a method of communication. Often the president, or maybe the president and one other board member, will be the contact person. You may need to establish different contact people for different things, depending on what type of problem you have. Is it an engineering issue? Are you going to be dealing with the police? Will it be with the city of New York? And maybe there'll be regular meetings set up. Maybe the board will generally get regular emails, while you're authorizing 1 or 2 board members to deal with specific issues and report back. So I mean, that's really critical. It's sort of common sense. It's a way to try and make sure you keep the legal fees under control. And there's one other thing you need to do, and you need to be careful, very careful about what you write. I think I once had a law professor back in the day who said to me, every sentence you write runs the risk of being read. I mean, think about that. The email, you want to send to another board member, in an offhand, off color kind of way. And once you have a problem in the building, which is going to wind up being a 6, it could be a 7-figure problem for the building. Once you put something in writing, it's part of the record and it's there. So you need to be really, really careful. I mean, one way to cover yourself is having the lawyer copied, which of course means if the lawyer's copied, he may or may not bill you for it. But it's really just a function of being careful with what you do. So that's really real important from whenever some kind of a problem starts. You set up what different players are going to do. You think about what you're going to put in writing, and you buckle your seatbelt, because some of these, for example, some of these items listed on the graphic that Elise put up, as I say, it can literally last for years. So that's sort of step one: who you're going to communicate with.
And I'm really quick, Stephen, if you don't mind, from an AKAM perspective, though, because obviously we're contacting the attorney, we're making sure that we're minimizing legal exposure. But for a first step, who do you contact? Do we have a protocol at AKAM, Chris, that people should know just generally to follow?
Yeah, absolutely. I mean, so I think here the first person to contact, there are 2 different firsts, right? So the very first is if you're actually witnessing a part of the emergency and you're the person you're somebody who's responding, or unfortunately, if this is happening to your apartment, God forbid, we do have a response protocol. So if you call the AKAM main line, after hours or during the weekend, you will, be transferred to a dispatch team that will transcribe all the information about your emergency and your message, et cetera, provided you're not needing to call 911, in which case you should hang up and call 911 immediately. All that information will be taken down, put into a portal, and then email, phone, text message will go out to particular staff members and management members in a particular order in order to best expedite response on your situation. Most likely the resident manager and or the management executive on your property will be in direct contact with the board. In addition, your management executive will be reaching out to our own internal distribution, emergency response at akam.com, so that the higher ups are familiar with it. Claims know about it. Brian Boak from our risk management team knows about it, and they will start the wheels turning. And the management executive, in conjunction with Brian, will reach out to your attorney regarding next steps on all those bits and pieces. And as Stephen mentioned, start with the telephone, right? Not with the email.
Right. And then, I think what are some things that people don't realize are a crisis? Like, in my opinion, and this is my former life, not being in property management, I don't think I would have realized that a leak could have severe consequences.
I think first thing we should think about here is, well, certain things can spiral out of control. A leak can turn into a flood, number one. But number two, I think, and Stephen could opine on this better, and even Brian, is which of these potential emergencies have the potential to spiral out of control from a insurance and or legal perspective. I can tell you that the down internet is normally not, is going to be an emergency, or not paying my bill on time is not an emergency. But anything that can cause, in my world, immediate physical damage to private apartments or common areas or your neighbor's private apartments could potentially be a problem.
So that's where when the email goes out to the emergency response team, our claims department will reach out to the property manager to discuss the situation. The property manager is the boots on the ground, so they're going to do the immediate response of calling in a remediation team if that's needed, updating us on what they're doing, and then we will get a claims report from them if needed, if that's the type of situation it is, to be able to report to the broker reports to the insurance company will assign an adjuster. If it's a legal document that's received, a subpoena, a complaint, or just a lawyer letter, that will also be noticed to the insurance company, and if necessary, a insurance company assigned lawyer will be assigned. We don't want the buildings to just start racking up bills on their own lawyers for subpoenas and items like that, because insurance companies generally don't reimburse boards for racking up building lawyers' bills. That's why they have their own lawyers that they assign. And many times there's either a small or no deductible for those types of issues. So it greatly limits the out-of-pocket for the board.
Yeah,
So that's earmuffs, Stephen. Earmuffs. No, I'm kidding.
It's a work in progress. I mean, the way to stay out for board members to stay out of trouble legally, and I'll talk about it more a little bit, is to listen to your professionals. I mean, management is obviously, your experts. You hired them boards hire management to run the properties. Management does that. They know who to contact. They know who vendors are. They know who to reach at the city. They can reach the insurance people. So, management is the expert in managing your property, and that certainly applies in an emergency. Lawyers are, some are less shy than others, and some, will naturally, I think, try and be more involved, and that's a work in progress too. I mean, you may want to put the brakes on how much your lawyers do, but there are things you may need your lawyer to do. And, everyone who just spoke, I think, Christopher and Elise and Brian, they mentioned insurance companies appointing counsel. So that's very important. And, let me speak to that just a little bit. I mean, what it does, obviously, when your insurance company appoints counsel is the insurance company will pay counsel. The insurance company has panels. Sometimes a building counsel can be put on their panel for a given matter, but that's something you would vet out with management. But you need to see how quickly an insurance company can get their lawyers involved if it's necessary. Now that will not cover everything. In many, many instances, insurance companies defend against claims, against lawsuits, if they're not going to usurp the general counsel role of your lawyer. And if it comes that the building has to sue anyone, the insurance company lawyers likely won't do that. But again, that's the kind of thing that's a work in progress. And, ACAM it can certainly guide how it goes along in that regard, what lawyer should do what. I think, Elise,
That's correct.
that kind of summarizes it all, right, guys?
That's correct, Stephen. So if the board wants to sue somebody, that's when you need to go to your buildings lawyer or some other professional in that area, because the insurance company doesn't come into play when the building is suing somebody else. Only they come in to defend you.
I mean, and it's like anything else in life. I mean, there's not an infinite number of management companies that represent lots of co-ops and condos in New York City, even though New York City is a big place. I mean, there's a number. It's a finite number. There's a finite number of lawyers who do this type of work. And like anything else we all have to deal with in life, you want to get a team that's competent to deal with these problems. So, moving on a little and looking at the graphic on effective crisis communication, there are lots of different classes of experts, potential adversaries, enemies, who someone, a board member, a managing agent, a lawyer will need to deal with them. So let me go down them, and then if any of the ACAM guys want to add in, fine. Your shareholders and unit owners. Well, gee, it wouldn't be a surprise if any shareholders or unit owners in particular, wanted to have extra attention. Maybe their apartment is more affected by a fire, by a flood, by something. And there needs to be systems to develop to deal with them. I mean, there may be a couple of unit owners, there may be half the building. I mean, this building I had in Brooklyn with a fire, the whole building was vacated, everyone was displaced. So it depends, but surely as there needs to be efficient, thoughtful systems put in place for a council and management to deal with the board, the same is the case for dealing with constituents who are obviously very important. So below property management and council, sponsor or holder and unsold shares. Well, sometimes the sponsor or the holder of unsold shares or units, sometimes they're the bad guy, sometimes they're the good guy. I mean, you could be at a building where, and just so you understand the terminology, the sponsor originally converts a building, and at some point they become the holder of unsold shares. And in a condo, it's a holder of unsold units. But I mean, they could own a third or a quarter of the units in your building. They could still be on the board. The residents on the board could rely on them for help. The residents on the board could hate them because of past experience. So, that's another piece of the puzzle, that, this is someone who has to be dealt with, and maybe their expertise can be tapped and maybe not. I mean, I'll stop here. Elise, do you or anyone want to add anything to that? You have your experience with this, God knows, also.
No, I think this is great. I mean, I think, from an effective crisis communication, I don't know, Chris, again, from just operations standpoint, I know our managers have also, a way that they handle it.
I mean, I think Stephen said it right in terms of relying on your professionals in your management company. I would just say on my side, I'll just limit to the boots on the ground response with regard to communication. I would say that those of us on the webinar here have all been involved in some sort of a crisis, right? So for us, this is just Tuesday, right? Or I guess it's Monday today. It's just another day of the week, right? Was what I meant to say. So but for board members who have a fire or a flood or some other crazy thing that's going on in their building, it could be the very first time. And so what I've experienced is, in a gas leak or something substantial, there's a lot of fear, there's a lot of trepidation, there's a lot of I don't know what to do, I don't know where to go. You want to avoid the running around like a chicken with your head cut off scenario. You want to make sure that you just come together, you have a conversation with the managing executive, you have a conversation with if you have a remediation company, with your attorney, with these different parties, and you get all the facts straight, you make sure you're documenting everything, and then you decide if you need to communicate to your residents craft that communication very carefully so they understand, most importantly, that the emergency has been responded to. If first responders are required, they have come to the building, they have said the building is safe, that you can occupy the building. And then the next steps that are going on, hey, these apartments, were damaged, we've got the elevators up and running or what have you, whatever the systems or equipments are, need to be communicated that are down or have any issues with are communicated to the residents so that you can manage their expectations. Because as we all know, if you know the train is coming, you'll wait twice as long. So it's very important that you are communicating effectively, not just between yourselves and the people that are directly involved, the board, the lawyers, but the residents of the building who have never been in a building and don't realize that buildings today, for example, are designed in many ways to take into account life safety in place. You don't necessarily, want a fire in one apartment, 100-unit building doesn't necessarily mean the entire building needs to evacuate necessarily. That will be up to the FDNY, but modern building design is such that it compartmentalizes smoke and fire, and the FDNY is incredibly responsive. And the biggest damage to a building is usually the water, not the fire, for example. So yeah, communicating to your residents and crafting that communication carefully. And as Stephen would say, be careful what you send out. And if you're concerned, about the language of that document or that memo or that communication on building, like what have you, run it by your attorney and make sure that you're not misstepping, and you don't want to misrepresent any facts as well. That would be a big problem.
Yeah, no, that's a really a good point you alluded to, Christopher. Let me stay with it a little bit. What types of communications do you have with your shareholders and your owners? Talk about a landmine. I mean, talk about just a place where you can get into a lot of trouble. I mean, like I said, some of these problems, it can be. I mean, forget about that. It could cost a couple $100,000 or it get into seven figures. The kind of problems we all have, everyone on this call has experience with, it can freeze sales in your building. I mean, if not dealt with in an appropriate way, nobody is going to be selling a unit, or anyone selling a unit is going to be taking a haircut. This, it could go on for a substantial period of time if you have, some horrible thing happen in your building. And that, let's go back to the graphic and kind of go through a bunch of people and experts, which sort of ties in with this: the accountants, the financial advisors, bank lenders, potential buyers, engineers, architects, insurance brokers. They're all part of a team, which, in addition to helping you deal with whatever horrible thing you're dealing with, I mean, the building I live in, we had a fire a couple of years ago. Someone smoked a cigarette. Two people died, which gets to the bottom item. Grief counselors is needed. But, you can have things happen. And as a board, you're going to, you don't need to go run and call your accountant in 24 hours. But all these financial people, these trade experts, engineers, architects, any insurance issue, they're going to all be part of your team as you mobilize and move forward. And in terms of communicating with shareholders and unit owners, boards usually have a pretty good feel for their constituency. When are the natives getting restless? When do they need to get some information out there? I mean, it's usually, I often volunteer when I have one of these, building nightmares. I say, let me write it. And, inevitably a board member says, oh, well, gee, isn't that going to be more expensive? And I say, oh, well, gee, no, it's the opposite. If you want to do it and make me look at what you did and throw it out and I'll do it, that's fine. Look, at some point, and everyone's always worried what the costs are, and is whoever working for you in a co-op, are they worried about, are they more concerned with what they're going to make out of this? I mean, it's the elephant in the room. What can I say? Hopefully you trust your professionals. That's the goal. Hopefully, you have good experience with management. Hopefully, you trust your lawyers and others, and they're, establish their bona fides. But anything that goes out to shareholders and unit owners, I mean, it's something which is going to be seen by potential buyers, by potential buyers' lawyers. I mean, I think, as you all know, when someone's looking to buy a unit, you know, their lawyer gets to work and goes through board minutes and searches the public record and asks questions and looks under rocks. And if you have, you know, any of the kind of problems which we're speaking of, I mean, they're going to shine a flashlight on it. So anything that goes out in writing to shareholders and unit owners, and you know, certainly it is a good idea to put something out, and you want to give some information. You got to be careful, and it really should be by counsel. And I'm not saying you actually have to live by this, but you know, I love a good story. I got a lot of stories from my father. Two guys in a balloon, and they don't know where they are. And one guy says to the other, I don't know where we are. And there's a guy on the ground, and they shout out, where are we? And the guy on the ground says, well, you're in a balloon and you're in the middle of the air. And so one guy in the balloon says, well, that guy on the ground is a lawyer. And the other guy in the balloon says, how do you know that? And the guy says, well, he gave us information completely true and totally worthless. So, you know, you don't want to give out worthless information, but you got to really, really be careful that, you know, it's like in a soccer game or a basketball game. I mean, one bad play at the wrong time can kill you. So, you know, it's self-serving for me as counsel to say, let counsel guide you in what you tell your unit owners and shareholders. But whether it is self-serving or not, that's really what you should do, which segues nicely into talking to the media, which
Actually, yeah. Okay. And really quick, I just also, because you're talking about communication and we have a question about that, you know, just monitoring people becoming hysterical when they hear about a fire in a building, and, you know, how do you keep people from freaking out, but still having ongoing communications as the fire is put out? You know, they have instructions on the back of the door, but they don't rely on it in real time. And the fire department head is telling the staff to stay away from the intercom. So I think this might be a Chris question, but, you know, what are some of the ways that you can mitigate the you know, the chaos, even though obviously it's a crisis? How do you keep people calm?
I mean, a couple things. I mean, I think making sure that, for example, you know, going floor by floor, for example, especially the floors that are immediately above and below, you know, especially in the event of a fire, which is one of the scariest things. I would say, you know, communicating to those residents what's going on. You don't want to misrepresent any facts, so you want to make sure that you've gotten the 411 from the whoever's running the scene, from the FDNY there. Normally, your management executive is the one that's going to be doing that. They're going to get the all clear, for example, from the chief, to make sure they know it's okay to say, you know, go back into the building and whatnot. So I would just say it's literally as dumb as, you know, knocking on doors, you know, to the immediate neighbors and letting everybody know everything's okay. Often in emergencies or in floods, for example, we have posted somebody in the lobby so that anybody coming in and out of the building is aware that we are there, we are responding to the emergency, and we are working on it. But I want to circle back to something that Stephen said. I think it has an effect both on the legal side and on the insurance side with regard to the money. And we see this a lot where boards say, well, you know, upfront, I'm concerned about the cost of this, and they're concerned about the cost of project management too. Is something often comes up as well. But in my experience, the cost of the attorney, the cost of, you know, going the extra mile with regard to documentation, et cetera, is a drop in the bucket compared to the cost of a lawsuit or increased liability or increased insurance premiums. So I think keep that in mind. It's like, well, that lawyer costs, you know, $400 an hour or whatever it is he costs. There's a reason he costs $400 an hour, because he has incredibly good advice. But relative to the cost of what you could pay, if you miscommunicate the wrong information, could be exponential. So keep that in mind.
So it sounds like communication is key, and what you were about to speak to, Stephen, regarding the media is also very important, because obviously that could have significantly damaging effects. Do you want to speak to that?
Yes, thank you, Elise. Good luck trying to control what someone from the media is going to put in the paper. And I say that as someone, I was actually quoted accurately and faithfully in the Sunday New York Times 2 Sundays ago in the real estate section. But that was, that was a Q&A about a very specific sort of narrow technical legal issue. You can't control what reporters want to do, how they might want to spin things. And, I'm not just referring to what happens initially if there's an initial article in the paper. I mean, you could have something that's going on for a year or two or more. And it could be a problem in the building, whether from some type of, what we've characterized as whether it's a natural problem, a fire, flood, I mean, something like that, or it could be a fight. It could be a huge fight in the building, some kind of legal fight. And the board may think they can get a sympathetic ear if they're fighting with a shareholder about some legal problem, and the board knows the shareholder's wrong, and the board's absolutely sure they can get portrayed sympathetically to the extent it's going to wind up in the papers. I rarely advise board members to speak to the media or management even. I usually say leave it to the lawyers. It's my the story in the balloon, which I just said. Again, it's all under the category common sense, and you got to be real careful. Which, let's go into the next line item: local officials, politicians, governing bodies. The same sort of thing. It's not that you don't want to get government officials involved, but they often have an agenda. I mean, you can, and frankly, also if you've got tenants involved, you could have rent stabilized tenants in a condo or a co-op. And, the greater likelihood is that politicians in the media are going to be more sympathetic to rent stabilized tenants than the problems of co-ops and condominiums. So again, it's just all under the rubric. You got to be real careful what you do, where you step. So I think that addresses that point. Let me. Sorry, go ahead, Elise.
Oh no, I was letting you go.
So let me, I don't know, some of you may be feeling battle fatigue now. After you could literally have some of these problems can go for years. I mean, I had a building where a shareholder wouldn't allow access to fix someone's shower. I mean, the litigation went for years. It cost hundreds and hundreds of thousands of dollars. Shareholders are angry. The shareholder causing the problem would go on Facebook and put up all kinds of things on social media, which, okay, why don't we talk about that now? Same thing. I mean, board members establish chat rooms or means of communicating on social media, which is fine. But if you're getting into a situation which begins to look and feel like litigation or involves litigation, I mean, you shouldn't be doing that. That communicating about matters in social media. I mean, you've all probably read people get in real trouble in real life and go to jail because of stupid emails they send out. I mean, we've all seen that. I mean, an email is you don't get any protection, you don't get any propriety because you send someone an email at 3 a.m. and you thought it was private. It doesn't work that way. Anything you put in writing, as I've said, runs the risk of being read and taken down. So that's just another area to really be careful. So before I segue into legal responsibilities of board members, which I'll try and keep not to be too dry. Anyone else want to chime in on anything we've talked about, communicating, any of the issues we've raised so far?
I mean, it should definitely be, if somebody's going to communicate, it should be determined who is going to communicate. And it should be a designated party that does the communication. Having it being the lawyer is a good idea because that lawyer is going to keep it dry and simple, and protectable is a good way to word it. Right, Stephen?
Yes. I mean, the lawyer is your sword in the armor. I mean, it goes without saying. I mean, everyone wants to keep legal costs down. Everyone hates to pay legal fees. I mean, those are truisms. But, people need surgery for medical problems. I mean, you need things in life, and you just got to delegate certain things to the lawyer. And so let me give you a little overview then. which you probably have some understanding as board members what your legal duties are, and what your role is. I mean, you really serve. It really is the nature of a co-op. A co-op is a corporation under New York law. It's governed by New York corporate law, but a co-op is also a landlord. Now, the condo, you're not a landlord, but there is the real property law, which governs the relationship as an owner of real property. The key concept and principle of board governance and duties is a fiduciary duty, which, as you know, the AKAM graphic says, you have to act in good faith with loyalty to all shareholders or owners. The best way to stay out of trouble is the best way to address any of these problems we've all been discussing. Follow your professional's advice. And in legal terms, the legal phrase of art, and many board members, you probably heard this, is the business judgment rule. And it stems from hundreds of years of corporate law in New York State, and it applies to directors of public corporations, and it applies to directors of co-ops and managers of condominiums. Use your business judgment in good faith. The best way to have a defense to a lawsuit or any criticism is to say, I did what my experts said.
Whether Stephen, one thing.
Sure.
So one thing that I see happen with boards is they get emotionally involved in the issue. When you get one step away to either your property manager or to your lawyer or to your accountant or some other professional, they are no longer emotionally involved in the situation and can usually make a clearer advisory comment on what is the best thing to do, because the boards get involved in too much of the nitty-gritty where they get personal about it, and we try and stay non-personal.
Yeah, and actually, good segue into just kind of what is considered, I mean, personal and what private, and what could be used against you. So are texts the same as emails?
Absolutely, absolutely. I mean, anything, absolutely. And I'm glad you brought that up. I mean, I refer to
written
emails.
Written communication.
That's right.
Letter, email, text.
What about a recording, like
social media post,
carrier pigeon?
Anything, and it as Brian was saying, you get emotionally involved, and that doesn't mean you get emotionally involved in a bad way. It means you get emotionally involved. You're on a board, you see a problem, you're trying to resolve it, you're trying to do the right thing, you're frustrated because maybe shareholders and unit owners are criticizing you, they're sniping at you, who knows what's going on. So it's not that you're emotionally involved for any ulterior or untoward reason. You can be emotionally involved trying to do the right thing, but you need. Well, I'll tell you another one. The chicken and pig are walking along, and they see a billboard, bacon and eggs, and the chicken says, "Well, I'm really involved in that billboard. You see those eggs?" And the pig says, "Well, you may be involved, but for me, it's total commitment." And it's a hard line to draw. The only way I've been able to cope with being a lawyer representing boards and dealing with crises for 40 years is coming up with a story here or there, because it can all get deadly serious, and there's a lot on the line. And I think what Brian was just saying to you in a way was, you got to step back, you got to hold your powder. Don't fire off an email or a text because you're really angry that you've been going to meetings and losing sleep and explaining to your a spouse or significant other why this is taking so much time and you're not getting paid. You'll probably feel your apartment may be losing value, and some shareholder just put in Facebook that you're horrible and you should resign. Well, you may say to yourself, where'd the fun go? And, look, there are times, board members can resign. It's not a crime. And, it happens. I think most board members, when they've been involved in one of these serious problems that go on for a long time, I think they want to kind of see it to fruition. They want to, try and do the right thing. In which instance you have to, as Brian said, you got to just, hold back and hold your powder. And the way to stay out of trouble, and the courts are incredibly deferential. I mean, it's a very high bar for a board member to get in trouble. It is, I'm not going to say it's impossible for a board member to ever have personal liability, but frankly, you have layers and layers of protection legally, which your lawyers and management um, uh, will try and implement and make sure are there. I mean, you have your bylaws will provide you have rights to be indemnified by the co-op or condominium. Your bylaws will basically say, particularly in a condominium, the only way you can have liability is if you act in some willfully, intentionally wrong way. I mean, it goes without saying, you should never, ever, discriminate against anyone based on, any class. I mean, I don't even need to say that. I mean, I could talk about this for 20 hours, as could every lawyer. And there's also insurance. So for board members, which insurance companies cover you as long as you don't, purposely and intentionally do anything really horrible and awful. So you have lots and lots of protections and strong legal coverage by the courts for how you may act. On to navigating.
Can I follow? Oh, sorry, really quick. Can a problem, like say you are a participant, you're a board member during a crisis, and then you leave, the board. Are you still engaged because of the time you were on the board when this happened, or
So Stephen, let me take that one. So
Sure.
I'll take the beginning and then you can take the end. So board members are protected by what's called the Directors and Officers Policy. It's called D&O. Okay, that's basically your insurance if somebody thinks you did something wrong as a board or as a board member. So board members are covered once they're elected, even if they're not installed, while they're in office and after they leave office. So it's a continuous. So if your term is up and then some lawsuit comes in that names you, you're still defended by that policy. Stephen?
Oh, absolutely. That's absolutely correct. And, again, it goes without saying, back to trust your professionals. I mean, your managing agent, AKAM, they know the AKAM knows the ins and outs of dealing with the insurance brokers and insurance companies and who insurance is placed with in the first case. Insurance companies sometimes deny coverage. We all know what happens. Insurance companies are not popular. But even if that were the case, under the documents of governing co-ops and condominiums, you have a right to indemnification, to coverage by a board. And your board will appoint counsel, whether it's insurance counsel or their counsel, to defend you, even if you're off the board, as long as you haven't, done something that would, be literally intentionally wrongful or fraudulent. So your back is protected being on the board in a whole bunch of ways.
Great, thank you. So, as we wrap this up, after a major incident, what are the steps that boards need to do to navigate their insurance issue, prevent financial fallout, be able to handle themselves operationally? As you mentioned, it might take a few years to have a remedy. So people need to be methodical, I think, with their process, who they contact, when they contact, obviously lean on the board management and their professional teams. But, what are your recommendations?
Well, again, it's right back at you, Elise, and AKAM. The board members rely on management to notify insurance brokers and deal with the insurance company and the claims process, and your general counsel will do the same. if it appears that you have some kind of a building-wide issue that needs to go in your financial statement, then management and council will work with the accountants. I mean, accountants have all kinds of rules they're guided by, professional rules. They have to report certain things. Other things they don't have to report. No lawyer or managing agent for a co-op is going to ask an accountant to do anything that they can't do. Having said that, if there's a way to have the financial statements represent something fairly and accurately without making it sound like the house is falling down, that's desirable. So all these professionals need to be dealt with. I mean, on behalf of boards in situations we've been talking about, the bottom couple of items about photo documentation and retaining damaged equipment. I mean, absolutely. I mean, this is evidence. I mean, from day one, your lawyer, your insurance people, everyone, gonna be looking towards what's a potential litigation risk or problem. So everything has got to be retained. So to the insurance and risk guys with AKAM, you guys, anything you want to add to that?
So in reference to a claim, so I'm going to go over a couple of them really quickly. So if you receive a legal letter or a summons and complaint, that would go to your property manager, and your property manager has the chain of command to follow to get that to the right people and get that processed. If it's a property claim, like a broken pipe or a fire or something like that, again, your property manager has certain protocols to follow to make sure everything is taken care of. They're immediately contacting a remediation team. If a building engineer is required, whatever teams are required, those people are getting notified immediately. Then the insurance company, the broker is notified, the insurance company is notified, the insurance company will send out an adjuster to take a look at the claim to determine what's going on. The first thing that should happen should be pictures are taken or video, whatever is appropriate for that situation. So you have documentation of what is going on so that after it's preliminarily cleaned up, everybody can see exactly what was happening. And then we just follow through and we get the appropriate teams involved. If units are involved in reference to damage, the unit owner or shareholder needs to notify their insurance company, because depending on how your governing documents are written, the building is going to be responsible for certain items, and the shareholder is going to be, or unit owner is going to be responsible for certain items. It doesn't matter even what kind of insurance you have. That's the way your governing documents. Both of those companies look at the governing documents to go, oh, this is a completely redone unit. The building is only responsible for the walls and the ceiling. The unit owner, since or shareholder redid the entire apartment, so they are actually responsible for the cabinets, the floors, the paint, everything. Okay. So you have to go to your governing documents, but both parties have to notify their insurance companies. So both insurance companies can inspect the damage, determine what is their responsibility, and settle that damage.
Ryan, really quick, but in case people haven't used them before, what exactly does an adjuster do, and is there a cost for that?
So an adjuster in general, there's two types of adjusters. There's an insurance company adjuster and a public adjuster. Okay. An insurance company adjuster is somebody that's assigned by the insurance company, that the insurance company pays for, and it's part of the expenses of the claim. And they come in and determine what was damaged and how much they believe the damage is. Okay. There's also what's called a public adjuster. A public adjuster is somebody who is hired directly by the building to work on the claim and work directly with the insurance company, basically cuts everybody else out. And then they get a piece of the claim, generally in the ballpark of 10% in the ballpark. Generally, for most claims, you don't use a public adjuster. You might use a public adjuster if it's going to be like a really, really large claim, or if it's going to be really a crazy claim, something like that. You may use a public adjuster, but you got to realize whatever the claim is, the public adjuster is going to get a piece of it. And in reality, nothing against public adjusters, but the bigger the number is, the bigger the claim number is, the bigger their commission check. So, and we really want to hold the claim down as little as possible, because the bigger your claim, the more it's going to affect your insurance renewal. So it's kind of a battle there a little bit.
So is
All
there,
I can say at this point is, if you're a thoughtful board member, your head should probably be spinning. And yeah, because it's a lot, as you can see, there's a lot of different things, and to make it spend a little more, even, you could wind up with more than one lawyer. I mean, you could wind up with lawyers for different types of problems. I mean, it reminds me of I don't know, I had cataract surgery recently. There's cataract ophthalmologists, there's retina doctors, there's 18 different doctors to deal with your eyes. And the kind of problems you could have, you could wind up with a bunch of lawyers, and again, who have expertise in different areas. And that's something management and your general counsel will help guide you on. Okay, let me stop, Elise. I don't know if you want to do any Q&A.
oh no, it's okay. Well, yeah, that we've been asking questions throughout, so that's been great. But there is a question about if emails and texts are deleted periodically, is this a problem, or is there an expectation to preserve them?
There is an expectation to preserve them unless there's a pretty good, damn good reason why you're deleting them. It's not good to delete things after something which sort of may go into litigation starts. I mean, you can explain it away that you clean your texts out every now and then, but it is not good to be deleting things, and the way to have to avoid that is don't say things that are going to get you in trouble.
Got it. And then someone was complimentary, which was just that someone had a fire in their building and AKAM came immediately on site and handled everything so effectively. So that's great to hear. Hopefully we will not be encountering, crises and emergencies, but I think that the likelihood of something minor, which feels like a crisis, will happen at any given time. And I know you always say fire, flood, and blood, Chris. I think that's your favorite saying. Usually happens on holidays. I know we have upcoming holidays like, Memorial Day weekend and July 4th, and those tend to be days that unfortunately things happen. So is there any last, words of wisdom that boards can use to just protect themselves that you all have to share?
Yeah, if you handle things right and sort of stick to what we're saying, maybe something you minimize the likelihood that it morphs into an absolute nightmare. I mean, you keep it under control, and you try and get it under the more ordinary course of business rubric that's being handled by all your professionals, and not becoming a cause celeb in the building. That is always what you want to do.
I always sort of default to, and I think it's true of all of our angles on this, is just being proactive, not reactive. Obviously, we are reacting in an emergency, but we want to have those things in place. Who is your attorney? Who is your insurance contact? Who are all these different vendors that are involved? If you're going to use your mediation company, do you have one on hand, one that you trust? Do you have a valve shut-off map at the front desk? Do you know where your local fire department, your hook and ladder company is? Just being prepared in the event that you do have an emergency. Knock on wood, you don't have one, but I think that knowing who your professionals are, knowing who the trusted team members are, and then also taking a minute to just talk about this with your team, with your staff, with your management executive, talk to your attorney, just have a good understanding, especially if you're newer to a board and you've never been on a board in a building. That would be my piece of advice, because you don't want to have to be like, oh my gosh, who do I call? Where's this information? I don't know where the map is, or I don't know this, that, and the other thing. You want to, they say that the military says you fall to the level of your training. So the more prepared you are, the easier it will be. You will just default to what you've already done the legwork on. So it'll be a lot easier and a lot less stressful.
Great. Brian, any last thoughts from you?
Just follow the advice of your professionals. Remember, you're on one board, maybe you're on two boards. Like, my team oversees the insurance on 700 buildings. I'm sure Stephen has hundreds of buildings or whatever that he is the lawyer for. We've seen every one of these situations. It really doesn't matter what the situation is. We've seen it, or one of our team members have seen the situation. This is something we're used to, we're trained for. Let us help you.
Great. And the last question is, how is knowledge of where your closest hook and ladder fire company helpful? Chris, that was directed to you.
I mean, I think it can be helpful in the event that you want to have a main point of contact for that local agency. You're not, a couple reasons. Number one is that way you know who to talk to if they show up at your building. And number two, one thing I really like is knowing that the FDNY will actually come to your building when there's not an emergency and have a conversation with the building staff and with the residents and the board members of the building to discuss fire safety and those sorts of things in your building, life safety in general for any of these potential emergencies, power outages, you know, et cetera, et cetera. And they will give you some good advice and some good practices that you can do, you know, when you're not in emergency. We always like to say, you want to make sure that that boiler is fully operating before it's 10 degrees outside, right? It's the same idea.
And I would agree with Chris. And I know some of our buildings have had the fire department come in either before any issues happened. We've also known them to come in after, so that for the next time they can be more prepared. And that's, the fire department is very happy to come in and help us understand what's the right thing to do, because that helps them do their job when there's a real problem.
Great. All right. So thank you all for joining us. We really appreciated your time. Thank you, Brian and Stephen and Chris, for your time. And if there are any other questions, please feel free to email us. We're happy to circulate this webinar after, as well as some tips that are key takeaways to share with your fellow board members. All right. Have a great day, everyone. Stay safe. Thanks.
Thank you, everyone.